My lord, my matter was there yesterday in the list. It was item number 40, 45. Today it is item number 30 and 34, my lord.
Yes.
My lord, I know, my lord, there are certain matters which have been fixed prior to those. My lord, those have been fixed in after the vacation. So if my matters are not taken up today, my lord, I will be in some difficulty.
No, we'll take up. We'll take up only those matters which are very urgent, so that
Because I'm told, my lord, there is a
very urgent matters are
because there is one education matter which has
that
been
is at 12.
12.
12.
So if this matter is taken up, my lord, in this half, my lord, I will.
Yes, I will immediately take up. And please, amongst yourselves also, don't press for those matters which can wait till after the
Yes,
vacation,
right.
because
My lord, I am
matters where condonation of delay and all those sorts of things for today.
no, my lord.
Let us take
my
up
lord, I
those
have
matters
challenged the
which
show
are.
cause, my lord, I have come up before you. Lord.
Yes, I'll take
Item
up.
number 30 and 34.
I'll take. Sure.
Matter file 16 December supposed to appear today. There is bank attachment. Last week may fix my lord after vacation on 5th my lord I am praying.
Appear.
Praying for leave to file in a vacation bench. This matter relates to the land. My land. It is in the possession of another person. He planted a deep tube well, and the area comes under the red zone of the government of West Bengal. That water cannot be irrigated, and he has obtained electricity without any due process of the law and using
Vacation bench.
Well, they have permitted one urgent matter bank attachment to that.
But yes, it will appear after the vacation. Yes. Today,
Item 39 and 40 of today's regular from the urgent determination of justice matter of blood. Kindly take it up on any time today.
let us see. We'll proceed. We'll definitely take up if it can be taken up.
I shall
You be here. Don't come back and go, because at any time, if the list collapses and you miss your chance, it's gone.
My lord, mentioning for upgradation of a matter, my lord, matter is
Upgradation, please give the list today. It can't be upgraded. Today is the last day before the vacation.
my lord.
Give
Then
the list.
after vacation, and also my lord, there is an analogous matter we want to tag it.
Give it. Don't waste time today. Yes. Chalo, call. What is the urgency?
And upon summons, one of the person in the notice has been arrested. There are two other notices.
Leave to move vacation. Yes.
Lordship, I'm for the petitioner. Lordship, I'm praying for an extension of the interim order.
But I'm for the state respondent.
Why are you offline?
Well, today.
Offline in the other sense. I'll not pass any order. I will extend the interim order. I'm allowing the writ petition because you are online.
I know my lord would not do this.
This matter is appearing under the heading extension of interim order upon being mentioned therefore. Full stop. Learned advocate appearing for the petitioner. Affidavit in reply. Seek some more time to file affidavit in reply to the affidavit in opposition filed on behalf of the respondents. Full stop. Time to file affidavit in reply is extended by 2 weeks after reopening of this court after the ensuing Christmas vacations. The subsisting interim order is extended till the end of February 2026. List this matter immediately after expiry of the time fixed for filing affidavit in reply.
Lordship, it is my humble prayer that at the time of hearing, let all the
Yes, you have mentioned it yesterday also. I remember it. You remind me. All those will be taken up together. Yes. For hearing, list for hearing. Yes.
Wait, please, Lordship.
Mr. Amit Sharma is appearing. From 3 to 6, I am appearing.
No, the
Similar matter,
may only indicate, Lord, item 2 and 3. It's all for extension of interim order, Lord. Item 2 and 3, Lord, is WPA 4147 and 4324. In this, Lord, the interim order is till the end of December 2025. That's paragraph 9. This is the order, Lord, dated 25th of September 2025. Lord, paragraph 9.
Yes.
Till the end of December 2000, I'm praying for an extension of the interim order, Milord. And Milord, kindly also grant us time to file the affidavit in reply.
My lord,
Kindly extend that time, my lord. 2 weeks post vacation, we'll file the reply. They've given the affidavit in opposition, my lord.
But these matters are appearing separately. They are not appearing
They're appearing
together.
separately.
my lord, they are appearing separately on all are 127 matter. my lord.
4147.
4147 is the first item, my lord, item 2. Then item 3 is 4324. That's the
Very well. So we'll go one by one.
my lord.
This is 4147. Interim order is expiring in December on
December
31st
2025.
Very well. Affidavit in opposition has not been filed.
My lord, I don't think Mr. Sharma is appearing item number 2.
My lord, they have filed it. I find, my lord.
Okay.
We have been served. I don't know whether it's been filed, my lord. We have been served with the copy.
But it's not there in record here.
They have not filed it yet, my lord.
They'll only file it if the matter appears.
My lord.
That's how. No, it's filed.
My lord.
Right. Likhun.
matter. And paragraph 6 of this order, my lord. 18th July 2025, paragraph 6. Assessment proceedings cannot be continued further. This be extended, my lord. Although there is no time here.
No, not required to be
Not
extended.
required, really, my lord. Not required.
It's not until further
My
notice.
lord, my lord.
Affidavit in opposition filed on behalf of the respondent revenue authorities is taken on record. Full stop.
Is WPA 4992.
But I am appearing opposition already filed.
Paragraph 7 of the order of 17th September 2025.
Abide by the result of the
Yes.
petition.
No, that's so it's extended, my lord. There's no extension. Only time to file the reply may not be extended by 2 weeks. My lord.
We same. Affidavit in reply opposition filed. You
Already
have filed
filed.
now.
They filed the
Already
my lord,
filed.
opposition.
Earlier filed.
I'm very deeply obliged, my lord. Very deeply obliged. The best kind of matters for the last day. My lord, I wish your lordship a very happy vacation.
Thank you. Same to you.
Very deeply obliged.
I'm going to respond on 13, my lord. The interim order is expiring on December. Sir. But I am praying for extension, my lord, for some time for filing affidavit of opposition.
This matter is appearing under the heading extension of interim order upon being mentioned.
That this matter should appear along with our writ petition.
But item number 8, my lord, I'm appearing. Mr. Mantha is there, but I was appearing because your lordship's screen was gone, my lord. I did not understand.
Yes, Malas, the first writ petition is ours. I'll tell your lordship what has happened here. There is a residential property, a part of the residential. No, if I may move my writ petition, if I may just move my writ petition, this is the first writ petition is on.
What is it appearing for? It is appearing for
Extension of interim order, Malas.
Appear without our writ petition. There is a direction that
Malas,
the writ petition should appear together.
both are appearing in the list. Both are appearing in the list.
Now,
So,
kindly.
both are appearing. No, then kindly, Malas, let me place my writ petition at least. My writ petition is appearing first. Malas, kindly let's be.
one by one.
Malas, if I may place my writ petition, Malas, I'll tell your lordship what has happened here in a gist. It's a residential property situated in Salt Lake. I'm the 2/3 leaseholder in respect to the property. Malas, 1/3 leaseholder who's a family member assigns the property to a private individual who has opened a cafe and a hookah bar over there without obtaining any permission from the sanctioned authority. Malas on the I filed a writ petition. Malas, I'm a senior citizen. I have a 3-year-old grandchild who's residing on the property. I complain to the authority saying I make an RTI over. I ask whether any permission had been obtained for operating this hookah bar at the said premises. The RTI response was no. I make a representation over Malas. The representation is not disposed of. I prefer a writ petition. On the first day when the writ petition is taken over Malas, the state authorities are asked whether or not you granted any sanction to the private respondents to operate this cafe or a hookah bar at the premises. The answer was categorically no. Thereafter, Malas, the state was asked to submit a report. A report on the form of an affidavit is also there before your lordship, where the state has categorically said that a show cause notice has been issued upon them to demonstrate as to what exactly, as to why this cafe should not be shut down. This report also indicates that there is no permission for operating cafe hookah bar. An interim order has been passed, Malas, thereafter by His Lordship Justice Hiranmaya Bhattacharya, restraining the
14th of
operation
November.
of the cafe and the hookah bar, Malas. That is what I'm seeking extension of. Thereafter, Malas, they prefer a writ petition challenging the show cause notice that has been issued by them. And they have also, Malas, said that my consent is not required at all in order to operate the residential premises for commercial use or for conversion of use of the property. There's an interim order that is subsisting, Malas, will kindly extend it for a short period.
Yes.
When the interim order was passed, there are certain documents which are not placed before the Honorable
Mr. Banerjee, the
Yes.
interim order has been in operation for some time.
That has
just
been an
before the
operation.
vacation,
Then we filed the writ petition.
in your writ petition also there is
May I
no
just
interim
indicate
order.
what has happened after that. My learned friend has indicated selective facts. After the interim order was passed, we filed our writ petition bringing to the knowledge of the Honorable Court that certain developments have taken place and certain things have been suppressed, have been misinterpreted. Then this writ petition was filed. My Lord Justice Bhattacharya was kind enough to hear us extensively for one day. Kindly have a look at the last order passed. It was my Lord Justice Bhattacharya's desire that since we are suffering an interim order, we should be given a total hearing and then the question would arise to pass the next order. That is indicated in the last order passed, which is at the top of this bunch of documents. Now the notification which my learned friend is talking of, that notification even debars a lawyer from running his chamber from his residence.
Order,
There is a chamber being run
Banerjee,
from the same premises.
we are on the closing day. Hearing of this matter is
This
impossible
is
now.
my we should operate
But
during
the
this
interim order
Christmas more.
interim order is in effect till December 20.
Then Christmas was not there. Today, we are entering into the Christmas vacation. Kindly, visualize the predicaments of a restaurant owner.
Mr. Banerjee, today I cannot vacate that interim order which is still in operation till 31st of December.
Hear us for
Today
10
it's not
minutes.
possible. So kindly don't make prayers, Mr. Banerjee, which is impossible for the
Then
court
we'll
to
meet
entertain.
again on the reopening.
Yes, that I can
understand that
definitely.
sometimes we
Yes.
also get unreasonable.
Yes, I understand that, but today, given the situation, I cannot enter into this hearing mode as of now. Limited interim order, I'm extending it only till I'm fixing it on the reopening date.
Yes, I won't object to that. I understand. I won't object to that.
Only one request, my lord. Only one request. Lordship will not keep it before the 5th. Reopening is 2nd, 3rd, 4th, my lord, is a weekend. Lordship keeps it on the 5th.
No, I'll fix it on 2nd.
Livelihood of 30
No,
to 40
2nd, my lord, I'm
persons
not
have been
there.
affected.
My lord,
No,
2nd, I'm not there. My lordship keeps it on the 5th.
I didn't want to disturb this.
Third
Third is a Saturday. Lordship keeps it on the
Second, have
5th.
it on 2nd.
No, 2nd, I'm
Let
not
us be
there, my lord.
reasonable.
I'm not there. My lord, they've had the interim order for since month of October. My lord, they can't come and my lord, dictate, my lord, one day. I'm only asking for one
If
day's
somebody
adjournment, my lord.
wants to use the court as a stratagem for the purpose of bargaining, that's one aspect of the matter. Then
No, they are bargaining. I'm not bargaining.
We'll have to close down a lawyer's chamber then. That's the
My
purpose
lawyer,
of
my chamber.
Mr. Nayak,
What
you are not the advocate on record. If you are not there, ask the advocate on record to make some arrangements so that somebody else is there. Barely because you are not there.
My lord,
you
I'm
can't
only
expect
asking
the
for
court
my
to
lord one day, my lord. That may be considered. Instead of 2nd, I'm saying 5th.
Mr. Nayak, you have made your submissions. I'll extend the interim order only till 2nd. On
Great,
2nd,
good,
it will appear. You pray for extension again on that day.
I'll not be there. I'll only repeat Mother Prayer, my lord, one last time. If your lordship only considers it Monday instead of Friday, I leave it to my lord.
down a business, 30 to
Mr.
40.
Majumdar on Monday, 5th.
No.
5th is on Monday. 5th is on Monday.
I'm grateful, my lord. I'm truly
This matter.
There is an application taken out by us, the leave of Mr. Bojunda.
For vacation of the interim order?
Very well, I'll
That
give.
should be hard.
Yes, yes. WPA 25295 of 2025. এইটাতে order record করবেন. This matter has appeared under the heading extension of interim order upon being mentioned therefore. Full stop. It appears that
Malas, the interim order is dated 14th of November 2025. Malas, will find that. That's it. Orders. Malas, this is the interim order dated 14th of November. So what is Oh, then I shouldn't have troubled your lordship with a separate copy.
that by an order dated November 14, 2025, this court had passed an order of injunction restraining the respondent numbers 4 to 6 from running any cafe, restaurant, and stroke or as a hookah bar in the ground floor of the premises being AD-70 এগুলো italics এ করবেন কারণ কোড করছে 770, sector -1, Salt Lake City, Kolkata 700064 till the end of the month of December, 2025 or until further orders, whichever is earlier. Full stop. Paragraph. The said interim order is thus in operation and is subsisting. Full stop. Paragraph. The same is extended till January 5, 2026. Full stop. Paragraph. নিচে লিখুন আচ্ছা ওইটা সেম ইজ এক্সটেন্ডেড এর আগে একটা লিখে দিন যে during pendency of the writ petition and subsistence of the aforesaid interim order, another writ petition being 25295 of 2025. This writ petition was filed subsequent to the
It was 27281.
Yes,
27281.
It is 27281.
27281. Sorry, 27281 of 2025 was filed by Mr. Mojumdar's client. Full stop. In the said application, in the said writ petition, an application being can one is the other one.
No, can one has been filed in 25295.
Yes, I understand because it is for vacating.
Yes.
Yes. এর উপরে লিখুন কেন এর উপরে 2595. Since the interim order was operating against the respondent numbers 4 to 6 ছিল না
4, 5 and 6 minutes.
4 to 6. Therefore, the said respondents, filed an application being Can 1 of 2025 seeking vacation of the said interim order. Full stop. তারপরে লিখুন during pendency of the writ petition, the respondent numbers 4 to 6 in WPA 25295 of 2025 filed an independent writ petition being WPA 2728. 4 to 6, it's only one of the respondents.
One of the
which is respondent number 4. Respondent number 4 to 6 na kore 4 korun. 4 filed in an independent writ petition being WPA 27281 of 2025. Full stop. The said writ petition was heard by this court on November 27, 2025, and the same was directed to be listed along with on December 2, 2025. Full stop. এর আগে আরেকটা লিখুন এখানে অনেক গন্ডগোল হচ্ছে কারণ দুটো আছে তো এর আগে লিখুন on November 27, 2025 when WPA 25295 of 2025 was heard, it was brought to the notice of the court that The respondent number 4 in the said writ petition had filed an independent writ petition being WPA 27281 of 2025. Full stop. The court, upon hearing the parties, directed WPA 27281 of 2025 to be listed along with WPA 25295 of 2025 on December 2, 2025. Full stop. Paragraph. On December 2, 2025, WPA 25295 of 2025 and WPA 27281 of 2025 were heard together. Full stop. The matters were directed to be listed on December 4, 2025 under the heading motion, since hearing thereof was not concluded. Full stop. Paragraph. The matter is appearing under the heading extension of interim order passed in WPA 25295 of 2025 today. Full stop. Today is the last day prior to the last day before the ensuing Christmas vacations. Full stop. In such view of the matter, the interim order which is already there till the end of December 2025 is being extended for a limited period till January 5.
It being a day for publication of monthly list, will be your lordships can pleasure to up 6th or not upgrade it in the monthly list.
It will appear as a motion only because that list is not mine.
Oh,
so I'm
Kindly
moving from
direct
6th. Interim order is extended till the till January 6,
Yes.
2026.
I'm grateful.
Full stop. Since this matter had been directed to appear as motion on December 4, 2025, the same would appear as motion on December 6, 2026 together. These matters will appear together on January 6, 2026 for further consideration.
Only one humble submission, but this extension is without prejudice to my application in the defecating application.
Since
Because the special bench has not yet decided the
Can
matter.
1 of 2025 has not been heard, it will be open for the petitioner in WPA 2. It will be open for the applicants of Can 1 of 2025 to press the same when the matter is taken up.
Yes.
Grateful.
Yes. Grateful.
Extremely grateful, Malad.
No. It's your duty. It's your duty, and it's my fetter not to be able to take it. Because today, if I start hearing, it will not be concluded also, and it will be an unreasonable exercise on the part of court and everybody. No, it's your duty. You have to do it. But we all know the practical difficulties. It's impossible.
Absolutely.
Conclude a hearing matter today and then.
Actually, on the last day of vacation, especially, I understand. Great.
Thank you.
I'm extremely grateful, Malad.
না এই দুটো একসঙ্গে অর্ডার করতে এ তো কোনো ইন্টারিম অর্ডার নেই আর উপরের যা আছে একটা এক্সটেনশন হলো আপনি একটা দেবেন আমাকে অনেকটাই ঠিক করতে হবে
My lord,
I'm the petitioner, my lord.
the respondent, my lord, I am praying for an accommodation after 2 weeks after vacation. My
2
lord.
weeks, my lord.
Because-
I'm opposing.
because-
This is the last
My lord,
hard time I'm
yesterday-
mentioning, my lord.
Yesterday, I have
My-
received the brief
Malad,
yesterday.
this second prayer, I'm objecting, my lord. 2 weeks after vacation, Malad, it is very difficult.
You may have received it yesterday. Let the court finish first, then you start speaking. You may have received it yesterday. He has served it earlier. Writ petition was filed earlier. It was served on your clients, that is the respondents. You have not received, that is not the fault of the petitioner. So 2 weeks will be unreasonable. You prevail upon your clients. Ask for instructions. There is still 1 more week available to you. They are not going on vacation. Ask for the instructions.
My
Come
lord,
back.
Actually, my lord, they have to coordinate with Delhi.
The
in this
coordinate.
matter.
It's all available.
And
upon
my lord,
vacation.
May I place the
Telephonically,
case, my
email,
lord?
everything is
There is no coordination is required
He'll not
in
be
this
required
matter.
to travel to Delhi to get the instructions.
Malad, this matter is not required to take instruction. Malad, why I am saying, my lord, there is a Supreme Court judgment.
An adjournment is prayed for on behalf of the respondents to take time to take on behalf of the respondents, full stop. Learned advocate appearing for the respondent submits that he needs time to take instructions in such view of the matter. List this matter under the same heading on January 7th,
Great.
2020.
Grateful.
But we are appearing for the state respondents.
You have your instructions. That is
My
why
lord,
you are online.
What is the only when
I have taken strong exception to your online appearance today.
we are also managers.
And your
Today-
friends at the bar have also taken strong exception. to
Last
this.
day, my lord, he is sitting at
Last
home.
day you are appearing online. This will not be pardoned. You appear offline, then people will see.
Grateful.
Grateful. Yes. 18. Where is Mr. Banerjee?
I'm praying for withdrawal.
No, I'll dispose it off. Where is Mr. Banerjee? Ask him to come.
He's out. I apologize, my lord, because
This is not the way
yes,
to
yes,
draft.
I apologize.
This is not the way because this was not the order passed also. I had
Yes.
not passed this order.
This my
So you should
I
not
am
write
admit,
that way.
I am admit, my lord. And
No,
first,
admission is something you put on record. That is
Yes.
wrong. This was never
I
dictated.
apologize because I also never committed such type of mistake. First time, my lord.
This was never dictated. That is the problem. It would have been one thing to say yes, I have dictated, and then
No,
it was never dictated.
But it is all right, Maharaj. He will file a fresh one. I have guided him so that the mistakes don't occur.
Yes. I'll dispose this off.
Lordship.
But I'll have to record all this.
Lordship, he is filing a fresh application. Instead of keeping this, let it file it on 2nd, and on the 5th, my lord, your lordship may take it up.
Or I'll record this and
Well, if something is written in the records, my lord, it will be difficult later on. Sometimes we do not know what happens later on.
you have your instructions.
And this is, my lord, completely my mistake, my lord. I apologize.
It is actually, if it is not dictated, you should not write that.
Yes, yes.
If I had dictated that, in fact, the contrary was said, that
I understand.
you can approach.
My mistake, completely.
My lord, actually, some of the juniors, they become exuberant and they think that
No, it could have been, if it was correct, I would have
Correct,
taken it at
yes, madam.
stride. If it was correct, I would have taken it at stride. I thought over it. I recalled everything sitting in silence, but
I must take as guidance from my seniors also. It was my mistake, completely my mistake.
no, if it was a fact, if it was truth,
No.
then it was all right, but it is untrue. I did not dictate it at all. I did not say that.
After draft, my lord, I ought to have
You
checked.
mentioned it after 3-4 matters and
Yes,
said
madam.
that I should be given liberty, and that also these things were not mentioned. You said it should be given liberty so that I can approach in accordance with law. That was the mentioning. I asked Mr. Banerjee to appear then.
Yes.
So I recalled the entire incident yesterday.
Lordship, leave with us. Let us.
Mr. Rai, learned advocate, appearing for the
Item number 20. 20, my lord. There is bank attachment, a delay in appeal, my lord.
Who is appearing for the
State, Mr. Chakraborty. State GST.
Mr. Chakraborty has vanished. He's not there.
The name is deflecting.
No, man. I'm there.
Yes, yes.
I should be punished, man, and I come.
My lord,
What is the length of delay?
delay, my lord, 462 days, my lord.
462 days.
Yes, my lord.
17
And
months.
after, my lord, after, my lord, all notices, order uploaded in the additional portal, personal hearing not in the adjudication stage. Thereafter, bank attachment, my lord, in the month of August. And in the month of August, branch manager, Bank of Baroda, provided us the copy of attachment notice and DRC 13 recovery notice. Thereafter, within 3 days, we have filed the appeal. And on 17th October, rejected the appeal. Thereafter filed the writ petition, my lord. And on merit, my lord, no tax is payable because the proportionate ITC reversal issue there. But in this case, my lord, at that I am trader, my lord. For trader, it is not applicable at the outset, my lord. Because purchase goods, sold goods, taxable adjusted. Non-taxable purchase, non-taxable sales. So on merit, there will be no tax, my lord. And there are three natural justice violation in the adjudication. Is number one, all the notices order uploaded in the additional section of the portal in December 2023. Thereafter, my lord, in the show cause notice, my lord, written personal hearing column not applicable, my lord.
Yes.
And genuine difficulty.
And all notices under additional
before December 2023.
Lordship, Lordship, kindly see page 111. Emails were sent to the SEC. 111 first paragraph. I'll not say anything more. Emails were issued. This is not a simplicity case of additional notices, uploading in additional notices.
Number
111 minute first paragraph. This is part of the appeal order.
Page 111, Mr. Rai.
My lord, in para 9 of the writ petition, my lord, I mentioned, my lord, that para 10, my lord. This is para 9. Kindly have a look. Para 9, page 9, my lord.
Para 9, page 9.
Page 9.
Page 12. Para 9 is at page 12.
No, my lord, that is internal para. Para 9, my lord. Page 9, kindly have a look.
Page 9 of what?
Writ petition.
Yes.
Page 9 and para 9, my lord.
Page 9, para 9. Okay. Yes.
Yes, ma'am. Your petition has stated that senior citizen around 62 years, not technology savvy, had no proper idea about the GST portal registered email ID, which may communicate.
So if you have given someone else's email ID, then you have given that, chosen to have that as your address. If they have communicated at that.
Yes, ma'am. That is correct, my lord. But the petitioner, my lord, not technology savvy, my lord.
So he should not have given email ID then.
Then email ID is mandatory, my lord, for registration.
Then he should have created one, because if you have given someone else's email ID, it is your responsibility to keep touch with him if you have received.
For the, my lord, tax.
For that,
I may not be faulted, my lord, and your lordship, my lord, may some cost, my lord. And bank attachment may be also dictated.
Mr. Chakraborty, since you are online, accept some costs and get the delay content.
My lord, whatever falls last day, my lord, whatever falls from my lord.
He's an individual.
Individual, my lord. Senior citizen lady, my lord.
But my lord, this should not be a precedent. But everyone would come up and say that I have not given my email address. Kindly protect the department to that.
I'll definitely not go into that, because that is why I'm putting him to terms.
And middle portion, my lord, that bank attachment notice on 19th August received, my lord.
Very good.
And recovery notice is not received from department, received from bank, my lord. Recovery notice also not served to us. And my lord, already, my lord, 20% recovered, that I missed, my lord. 10% P deposit submitted and electronic credit ledger at page 98. Another 10% they recovered. So 20% already paid, my lord. Kindly consider the cost amount, my lord. I'm not saying, but I'm
No,
playing.
but you have filed appeal. So
appeal filed.
once appeal is
Appeal is
restored,
filed,
in
that's
any
what I
case,
was
it
saying.
will
No,
be.
my appeal is filed. Appeal
So
rejected.
once appeal is restored, they will all they will by way of this order lift the attachment.
Yes, attachment is now.
If appeal is pending, they cannot proceed.
Kindly,
That is
Madam.
the statute also.
Yes.
107.7.
107.
Yes, 107.7. There is a provision saying
Yes,
that
yes.
it will be automatic stay.
But now I'm praying, my lord, one line may be added.
All right, this writ petition assails an order dated October 17, 2025, passed by the appellate authority under section 107 of the WBGST Act, 2017 stroke CGST Act, 2017, whereby the petitioner's appeal against an adjudication order dated January 18, 2024 has been dismissed on the ground of delay. Full stop. Mr. Rai, learned advocate appearing for the petitioner, has, where is the application for condonation of delay?
Page 94.
Has taken this court through the application for condonation of delay filed before the appellate authority at pages 94 to 95 of the writ petition, and has submitted that the petitioner, being a senior citizen, could not keep track of the notices and orders passed, notices issued to the petitioner in respect of the proceedings and the order passed thereon. Full stop. It is submitted that the said notices and orders were uploaded on the GST portal under the additional notices and orders tab. Full stop. Paragraph. But that is not there before the.
Yes, they are, because December page, my lord.
That is not there before the appellate authority. That is not your submission before the appellate authority. We took it in. Now, notices and orders tab, but it is seen that such submission was not made before the appellate authority. Full stop. Paragraph. The appellate authority has dismissed the petitioner's appeal upon being dissatisfied with the reason cited by the petitioner. Full stop. It is noticed that the petitioner has, where is the, you have given any evidence of it was under the additional notices and orders?
Yes, my lord. Yes. At page, my lord, page 83, my lord. For orders and for notice, page 68. In short, my lord.
Petitioner, it is noticed that the petitioner has annexed screenshots of the relevant portal at pages 83 and 68 of the writ petition to demonstrate that the notices and orders were indeed uploaded on the GST portal under the additional notices and orders tab. Full stop. Paragraph. However, there is no explanation for the petitioner to substantiate as to why the petitioner could not keep track of the emails issued to the petitioner, except that the email ID, that the petitioner, being a senior citizen, is not technologically savvy, and he had to depend on the tax consultant for such purpose. Full stop. Paragraph. Having regard to the fact that that the petitioner is an individual and a senior citizen, and that the petitioner has been relying on the tax consultant. Where is that pleading?
Yes, my lord, at para 9, my lord, of the writ petition.
On the tax consultant for the purpose of his GST related affairs, comma, this court deems it fit to grant one more opportunity to the petitioner to present its to press its appeal before the appellate authority. On merits upon putting the petitioner on terms, full stop. In such view of the matter, comma, if the petitioner pays a sum of rupees 15,000 to the High Court Legal Services Committee within a period of
My lord, 3 weeks, my lord, I will pay, but
3 weeks,
as the package.
within a period of 3 weeks from date, and furnishes proof of such payment before the appellate authority, comma, the appellate authority shall proceed to hear the petitioner's appeal on merits, full stop. In such case, comma, the order impugned dated October 17, 2025, passed by the appellate authority shall be of no effect and shall be treated as having been set aside, full stop. In case the petitioner fails to make payment in terms of this order, comma, this order shall not inure to the benefit of the petitioner, full stop. WPA 24954 of তার উপরে একটা লিখে দিন. It is submitted by Mr. Rai that where is that notice?
Recovery notice at page 85, my lord. Starting page 84, 85, DR to 13, my lord.
This is after dismissal of the appeal.
No, my lord. After receiving the this notice, my lord, bank authority telephoned us, then filed the appeal on 22nd, my lord. Received on 19th August, my lord.
When is the this where is the attachment of the bank account?
That is not notice, my lord. That
this is only a notice that they will do it. But has the bank account done it?
No, bank authority, as the bank authority gave us, my lord, bank authority attached the bank account.
85 page.
It is submitted.
Page 85 is that form for attachment. DR 13, page 85.
It is submitted by Mr. Rai that on the strength of the adjudication order dated
My lord, 18
January 18, 2024, the respondent GST authorities have proceeded to attach the bank account of the petitioner, full stop. Paragraph. In case, comma, the petitioner abides by the conditions imposed in this writ petition and makes payment of the sum of rupees 15,000 to High Court Legal Services Committee as aforesaid, comma, once the petitioner's appeal is restored, comma, the attachment of the petitioner's bank account shall be lifted. WPA 24954 of 2025 stands disposed of.
My lord, may I pay, my lord, that little reduce, my lord, 10,000, my lord.
Why? Delay is too much.
And they recovered, my lord, total 20%, my lord. 10% pre-deposit and 10%.
Very well, that is refundable to you. This is cost. That is not related to it.
But affidavit of service.
Affidavit of service file.
I'm grateful.
On 25th of September 2025, the DRC-01 is intimation was issued to the petitioner. Asked the petitioner to file the reply on 29th September 2025. 25th of September 2020 was the Thursday. Asked me to file a reply on 29th of September 2025. This is Monday. And during the Puja vacation start in I think 26th of September 2025. we have filed a reply on 26th of September 2025. We have asked for the details on which ground they have the demand has been raised. They have stated only on the ground of that there is a alleged the tax on account of TDR, that on account TDR, and you have to reverse that only the TDR ITC has been, you have to reverse the ITC only. There is a demand on two account, but in the DSC 01A only reflect, there is no reflection at all. Only one HSN code has been different. Nothing has been. The 5 years they have demanded. In the 5 years they have asked for the demand, but they have not segregated anything. No details has been provided on which ground they are
passed
demanding.
the order.
Then, my lord, I have filed a reply on 26th of September asking me the details and everything. Kindly give us 4 or 5 days time because the vacation is Puja vacation. My lord, on 27th September, they have issued the show cause notice. Their notice under section under inform number DRC 01. Although they have asked me to file a reply on 29th September 2025. And subsequently, the covering letter is saying only 29th September 2025.
What is the immediate urgency now?
My
What has
lord,
happened?
otherwise DRC, they have to pass, they will pass the order, my lord. They will attach my bank account.
Your Lordship,
My lord, only
then only DRC 01 has been passed.
no, my
After
lord.
consideration of the DRC 01, Your Lordship, if Your Lordship may come.
My reply is, I've asked the document. Kindly see my reply, my lord. Reply at page 146, P13. My lord, kindly see first on page 144, where it is written.
But
We have
is
to,
it going to be time? But 1 year time is there, na?
my lord, 1 year they have to pass the order, my lord, 1474. My lord, adjudication order, my lord, saying only the adjudication order.
Yes.
Well, I am telling me they cannot issue the show cause notice at all, my lord.
Yes, but your attachment thing, apprehension of attachment will only become true after adjudication order is passed.
Well, I am saying they have no jurisdiction at
Yes,
all.
that we will consider. But
Well, it is very
before the
short matter.
vacation-
Only 5 minutes. I will not take much more time.
Mr.
5 minutes,
Mr.
my lord.
Mazumdar, I'll have to decide it then. Let us have it after the vacation immediately. What is the hurry? Because there are other matters, demolition and all are waiting. We can have it after the vacation. I'll have to enter into it. I'll have to pass a detailed order. I cannot.
Well, I am only on account of natural justice, nothing more.
I understand that. Still, at the stage of show cause, I'll have to consider.
Your Lordship, if they want to make any reply, we'll consider it. Your Lordship, for the they are asking for time for reply for DRC 01A.
No, he says you cannot issue show cause.
They
I'll
cannot
consider that. If I have to issue, if he's satisfied with that, I could have done it. But he wants the show cause to go. For that, I'll have to enter into this. Yes. If you want that, I can say that you along with
No, my lord. I have to place by case, my lord. I have.
लिखे दिन. Heard Mr. Mojumdar, learned advocate appearing. আর ওয়েট করতে হবে না আজকে তাড়াতাড়ি করুন অনেকেই ওয়েট করছে what is the matter and what is the urgency?
My lord, bank attachment, your lordship. My lord, the adjudication stage, my lord, the demand was 1 crore 70 lakhs. Your lordship. We preferred an appeal. the demand was reduced to 1 crore 34 lakhs. Your Lordship. Thereafter, my lord, we filed a rectification application. That is still pending. During the meantime, my lord, my bank account was attached, and I am ready to pay 10% of the demand, Your Lordship, the revised demand, Your Lordship, and my lord, bank account may be released here. Attachment may be
Lordship subject to payment. Why I'm saying this? Because in the main contention was that extend you have issued the notice, show cause notice and adjudication order beyond the extended period, and they have not challenged the notification, but they have said that this notification has been struck down by different high courts.
And he has come up with what? Adjudication order?
Your Lordship.
Yes, Your Lordship.
He's coming against adjudication order?
No,
It's coming against appellate authority order, and against that appellate authority order also he has made a rectification application which was rejected. Your Lordship kindly takes to page 56.
Very well. So I'll admit the appeal.
Your Lordship,
Admit the writ petition.
No, my lord, I am not on that, Your Lordship, because I have come here, Your Lordship, against that attachment.
Very well, I understand that, but
My lord,
I just simply cannot pass an order of depositing of 10% and attachment.
My lord, what I am humbly submitting, Your Lordship, this deposit of 10% may be treated as the pre-deposit for filing an appeal before the GST.
Tribunal. And I'll give you liberty to approach the tribunal.
Yes,
On
yes,
deposit of 10%, you leave the
yes.
attachment.
If it's secure, then
Yes,
payment.
my lordship.
10% hit
10%.
deposit, you, because in any case under 112 you could have done it.
Has to be done. I cannot.
लिखे नहीं Yes, madam.
My lord, this is a case for the restoration of registration certificate, not for the 6 months delay.
Not registration
After the
certificate has,
vacation.
because there's question of
He
fact
has
involved.
he has something to submit after the vacation.
Because
Immediately after vacation.
Fraud and
It's a contest now.
it is a contest because fraud and other things have been.
My lord, the show,
Very well, madam.
my
she
lord,
will-
my lord,
she will
the
hear.
show cause notice they issued for the non. Just a minute. My lord, they issued the show cause notice for you are hereby directed to furnish the no business activity in the name of the Infinity Trading has been functional at the declared place of business.
Second January. Come back.
Second, Lordship, not 2nd January. Lordship, we are not.
5th January. 5th corridor.
Much of.
5th January. We'll take off. 1 more week.
My lord, I'm for the petitioner, my lord. The goods have already been released by the department, my lord. So nothing survives for the adjudication in this present matter. So I may kindly therefore pray to dispose of the matter. These are the supporting documents for the release.
Goods and vehicle release, man.
Both.
Yes, obtain the goods and vehicle.
Lieutenant. Learned advocate appearing for the petitioner. Hands up to court. A letter dated
My lord, 28 and 29 are similar matters.
Yes.
My lord, this is a matter where regarding Service Tax Act under Finance Act 94.
What is the urgency before the vacation?
My lord, that's urgency is that bank account and Sunday debtors are attached of the petition of the
Who
petition.
is appearing for the respondent?
My lord, I have the affidavit of service.
No, it won't do. You have to serve a notice again, because if they are not appearing, I will not pass an order of lifting of attachment without hearing them.
My lord, I tried to contact, but nobody has been.
So today I cannot pass an order ex parte asking lifting of attachment. That's a serious thing. Making it not today, try or lock on second. Not today. Chalo.
My lord, same.
Same, not today.
Thank you.
My
But
lord,
I,
affidavit of service indicate.
No order is being passed. Not today, why appeal?
Lord, I appear for the petitioner, my lord. Finally, I got the privilege to appear before your lordship, my lord. But I am told Mr. Banerjee is appearing for the Central GST
Mr. Banerjee
Authority.
is right before you.
But he's telling me that he has not received the copy of the writ petition from the department. My lord, but we have served it long back, my lord. I think copy served is the 8 December.
Yes, Mr. Banerjee, then can we have it at 2 then? I mean, on second.
The difficulty is, my lord, they have issued a show cause notice, my lord. My lord, appearing for the respondents for more than a decade, my lord, I would usually jump in my feet, my lord, saying that the petition is not maintainable because show cause is being assailed before your lordship. Now, my lord, this show cause is without jurisdiction. I had threefold submissions to make before your lordship that this show cause is not at all, my lord, entirely without jurisdiction. But if they assure, my lord, they won't proceed with the show cause notice within this, my lord, interregnum. My lord, because
with 7 days will they proceed? Because
Well,
show cause notice will have some time for you to reply.
well, the show cause notice was issued to me on 26th of September 2025. But I replied to it, and thereafter, I filed a writ petition. That possibly due to the pendency of the writ petition, they have not proceeded. But
It is not going to be time barred. That means it is not.
Now the time limit for taking action has already expired, my lord. They may take action because I have replied to it. But I do not know whether they will.
No, but the proceedings are to be concluded within a period of 1 year, I think.
After show cause, my lord, usually it is within 1 year. Or it may usually within the time limit which is mentioned in the show cause notice.
No,
Date for personal hearing, date for giving written representation reply.
Second,
Huh.
in the meantime, let him give us a copy. We shall take
On
instruction.
second, we'll take
On second, we are there.
But my lord, I hope and trust, my lord, since Mr. Banerjee is here, he can ask this concerned officer who has called him up and told him that yes, we have received the copy of the writ petition, but he could not send him that writ petition, to ask him not to take any adverse step in the meantime.
Well, the adversity will only come after notice to him. During the vacation.
No notice is required anymore. Because after show cause, he can pass an order.
Hearing of it.
না কোনো hearing দেয়নি তো আমাকে. After show cause order pass করতে
So
পারে.
then that will be a good ground for your adjudication or the challenge.
Yes.
Non violation of principles of natural justice.
On second,
my lord. Your lordship may kindly keep it at the top, my lord. Because your lordship may kindly record that I have served the copy of the writ petition on 8th of December.
This writ petition mounts challenge to a notice to show cause dated
But there are many matters fixed on 2nd of January. So, if it is taken at the top.
Should I fix a time then?
But grateful.
Tell me.
Second to third.
Yeah, आपका 5 तारीख
Tell me. Tell me a time.
Matlab any time. Second, in the morning we shall do it.
নিচ্ছু না তো সেকেন্ড
No, no,
ফ্রাইডে আছে
নিচ্ছি না রে।
At 2 p.m. call.
at 2 p.m. I'm grateful.
At 2 p.m.
2 p.m. 2 तारीख
Grateful. Returning.
Your Lordship, I am for the petitioner in this matter.
Yes.
Your Lordship, I appear for the petitioner in this matter.
Yes.
I am sorry, Your Lordship, apologize at the beginning that I am appearing virtually. Your Lordship, kindly excuse me for that. Your Lordship, the petitioner is aggrieved by the pendency of a stay petition filed before the assessing officer on the basis of a demand notice raised under 156. Now, this demand notice is the basis of an assessment order which is already under challenge before the ITAT. Now, a writ petition was filed, Your Lordship, where an order was passed on 16th of September 2025 directing the ITAT to dispose of the application for restoration expeditiously. Now, the ITAT has kept the matter pending and the matter has been fixed on 13th of February 2026. Now, in the meantime, the Income Tax Authority has issued the demand notice and is proceeding with coercive action and has already declared me an assessee in default. Now, what I want before Your Lordship is today is a very limited prayer. Is that, Your Lordship, my stay petition is pending. I have given 4 reminders. Now, the assessing officer is not disposing of.
Where is
Yes, Your
this
Lordship.
petition, Mr. Banerjee?
Yes, Your Lordship. Yes, Your Lordship. Kindly come to page 287.
27.
I only want this application to be expeditiously heard. 287. Annexure P22.
287.
Yes, 287. Lordship, my limited prayer is that I want only this application to be disposed of expeditiously. And Your Lordship, in the meantime, they should not proceed because the matter before ITAT is fixed on 13th of February 2026. 287. This is the stay petition. Your Lordship will kindly come to the prayer.
I'm opposing, Lordship.
Yes.
Kindly come to the prayer. 1 second, I'm not finished. Now, Your Lordship, this prayer is at page 293, and we have given several reminders, Your Lordship, from page 298 onwards. 7 November 2025, page 298, page 311 November 2025, and page 302, the third reminder. Now, in spite of that, Your Lordship will kindly see at page 304.
Lord, his stay petition was earlier dismissed. Again,
No, not at all. This is the wrong submission.
Came and said that we are ready to make the payment.
1 second.
Attachment was withdrawn. Everything was there. Lord,
I have not finished making submission. I have not finished. Kindly see the coercive action that they have taken now, page 304.
No, but if your stay application has already been dismissed, they will.
No.
It was dismissed.
That is the wrong submission. That is the wrong submission. They are referring to a letter of. They are referring to a notice of 6th August 2025. Kindly come to the notice. That was challenged in the writ petition. And the High Court has. Your Lordship will kindly come to page. The notice at page 137. 137. Yes. They are misinterpreting this fact. They say it was rejected, but there is no order of rejection. Kindly come to page 137. Yes. It is evident from the record of the demand that rupees 3 crore 90 lakhs for assessment year 2002 is still payable by the SSC. The stay application dated 30th July to keep the demand in abeyance is hereby outright rejected as the appeal is dismissed. Now kindly see the communication date 6th August 2025 and my stay petition is of 3rd November 2025. How can this be disposed of before it is being filed? This is a communication which they are saying has been rejected.
No, your stay
and kindly say once.
Mr. Banerjee, it records your stay application of July 30, 2025. There was a prior stay application.
Correct. You know, this is not a stay application. That was a communication based on an earlier notice issued. That was not the subject matter of consideration.
That itself is an application, Mr. Banerjee. Before the authority, you are not required to file an application on affidavit. This itself is page 134. I can see now. Is 30th July 2025 is an application.
Correct, Your Lordship. Kindly see this demand notice which they are referring to 137 was challenged in a writ petition. Now kindly see what order has been passed.
Yes,
the High Court has left it open. 139. The High Court has left it open. The High Court has not considered this as a rejection.
Just a minute. 139.
139. No.
No, sorry, your lordship, is not 130. 1 second, your lordship.
270.
270. Sorry, I have given the wrong page number. It's 270. 270.
Yes. 270.
Yes. 16 September 2025 order. The instant writ petition has been filed to withdraw or cancel the demand notice dated 6th August 2025, which is the notice my learned friend is referring to, 137, issued under 156. Having heard the learned advocate for the respective parties' records reveal that being aggrieved by the order of 25th March 2015, passed under section 143 for the assessment year such and such, an appeal has been filed before the office of the Commissioner Income Tax on 16th April 2015. The appeal was subsequently dismissed on 3rd November 2016 for non-prosecution. Being aggrieved, the petitioners filed an appeal before the ITAT. Such appeal was once again dismissed for non-prosecution by the tribunal as would corroborate from the order of 20th August 2018. Following the aforesaid, a restoration application was filed, which was registered as MA number such and such. There was delay of 1757 days in moving such application. Since no one had put up the appearance on behalf of the SSC, despite notice, such application also came to be rejected on 22nd April. Being agreed by an appeal was filed before the Honorable Division Bench, being registered as such and such. By order of 6 May 2025, the Division Bench of this court, taking note of the peculiar facts and noting that there has been
Very well,
no...
Mr. Banerjee, I will direct them to dispose of the application, but no stay in the meantime.
Yes.
Because
Your lordship,
the-
your lordship,
bank
in
accounts
the
were
meantime,
attached.
Mr. Banerjee, there is no time. If you want, you can come back after the vacation. Today, this is going to be my order.
Lordship,
Clear.
only one thing.
Because
Only
arguments
one
are,
thing. If
Mr.
your
Banerjee,
lordship,
no arguments on this. I will not stay because the facts are very clear from page 270 to 272. Here also, you are not granted any stay. I am not going to grant any stay.
no, here, your lordship, I have not.
306,
Here, your lordship, I have not.
307. Lordship will kindly
1
have a look.
second.
306.
You have made an application. I will direct them to consider. That is the most that you can read before the vacation. If you want to argue, come back. Let us have it thrashed out.
Your
After the
lordship can
vacation.
fix up a time frame, your lordship, because the matter
That I will
before
do.
ITAT is fixed on.
That I will
Fix
do.
up a minimum.
I will fix up a time frame for them to dispose of the application in accordance with law.
Yes.
Yes, your lordship will do that. Lordship will do
Yes.
that.
Yes.
If your lordship, may I pray for only a particular limited time frame within which they will, because lordship, 2 or 3 weeks, if your lordship is kind enough to.
No stay, Mr. Banerjee.
Their director appeared and
High
they
Court,
said,
you have not got any stay on 16th.
Your lordship, High Court have not challenged the demand
No
notice.
change in situation, Mr. Banerjee. Your application for recalling, you did not appear before the appellate tribunal despite having filed an appeal. You got that application for recalling also dismissed. Facts are very gory. Here I will not enter and grant stay. It won't look good.
No, what the ITAT has done, your lordship, the High Court has directed my restoration petition to be
Very well. I will
considered.
also direct
Now,
your another application to be considered in a similar fashion.
no, what the ITAT has done, your lordship, only 1 second, your lordship, I have
I'm not on
understood
that,
what your
Mr.
lordship mind
Banerjee.
is.
Let us not argue. If you want to argue, let us fix it on a next date so that both of us can apply mind. Or if you want, you can get
then
that
your
order.
lordship will fix up a limited time frame for the disposal of my stay petition.
Very well. That's it. Yes. Who are you appearing for?
Everybody has been served, my lord. This is the affidavit of service.
We have served, your lordship, we have served.
there was an attachment
It's
which
not-
was revoked, my
It's
lord.
not an order against you. Don't worry. Affidavit of service filed today be kept to the record. Full stop. The writ petitioner assails notices dated November 18, 2025 and November 25, writ petition and November 25, 2026 issued under section 156 of the Income Tax Act 1961. Full stop.
My lord, before passing of the lordship, kindly see page number 306 and 307. My lord, they themselves, the director came and said, my lord, we are ready to make the payment. On their assurance, the bank account attachment was lifted, and subsequently they failed to make the payment. Now they are.
I'll record that. You will dispose of this petition.
Lordship,
whatever.
kindly have a look at 3067. My lord, I will not trouble your lordship. Page number 306 and 307.
My lord, with leave of my learned friend, learned senior friend.
Then you come after the vacation.
No.
No. So many facts are there.
No, your lordship will pass necessary orders. No,
No.
your lordship will pass necessary orders. Your lordship will fix up a time frame.
This matter for
Your lordship
further
will fix up a
consideration
time frame.
on
Your lordship, we
January
have no
5,
difficulty.
2020. You
Your
know
lordship
there
will
is a
fix up a
pressing,
time.
everybody wants a hearing. Let
No,
us
your
appear on
lordship,
5th.
no, your lordship
No,
will pass
no.
necessary
On
orders.
5th.
I am not pressing anything.
Next matter call.
Your lordship, I am not pressing for anything. Your lordship will fix up a minimum time frame. Your lordship.
I wanted to
Your lordship, I
dispose of.
apologize
Now
on
you
behalf of my
want
junior.
me to enter
Your
into
lordship,
that
kindly
on
dispose it
5th.
off. Kindly dispose it off. I apologize on behalf of my junior. Your lordship, kindly dispose it off. I am very sorry. I take the burden upon myself. Kindly, I apologize on behalf of my
Well,
junior.
there
Your
are
lordship will
fixed
kindly not
matters.
do
There
that.
are matters which are where there
No,
is
your
pressing
lordship will,
urgency.
your
The
lordship will
fact is
dispose
not
it off.
such that you want it
Your
today
lordship,
only.
I am not entering into the merits. Your lordship will dispose it off. Your lordship, I apologize on behalf of my junior. I am really sorry. Your lordship will dispose it off by fixing a minimum.
You know
Grateful,
there
your
is
lordship, please.
pressing urgency. Why
No,
unnecessarily if you want to
I
press,
am
come
not
back on
entering
5th.
into.
Let us have it.
No, your lordship, I am not entering into the merits. Your lordship will kindly dispose it off. I am very sorry. I take the burden on my shoulder. I am very sorry. I apologize on his behalf.
Subject to correction, stay petition is not at all pending. Well, it has already been disposed of.
They have made an application.
No,
Dispose of, reject it, whatever you have to do. They have made an application. Say you are not entitled or you are entitled. This matter would not have come up to court then. It appears that by an order dated March 25, 2025, passed under section 143 within bracket 3 of the said Act of 1961 for the assessment year 2012-13 by an assessment order dated such and such was passed against the petitioner under section 143 within bracket 3 of the said Act of 1961 for the assessment year 2012-13, full stop. The said order was carried in appeal before the CIT appeals, full stop. The appeal was dismissed on November 3, 2016 for non-prosecution, full stop. The petitioners carried the matter before the tribunal, before the Income Tax Appellate Tribunal, full stop. Such appeal was also dismissed for non-prosecution by the tribunal by an order dated August 20, 2018, full stop. Thereafter, an application being MA 121/:2023 was filed seeking restoration of the said appeal, full stop. The said application was delayed by 1757 days, full stop. Since the application was not pursued, the same was also dismissed on April 22, 2024, full stop. Paragraph. Assailing the said order, the petitioner appealed. Petitioner approached this court by way of an appeal, approached the Honorable Division Bench of this court by way of an appeal, being IT-AT 248 of 2024, full stop. The said appeal was disposed of by an order dated May 6, 2025, thereby setting aside the order dated April 22, 2024 and permitting the petitioners to apply afresh before the tribunal, full stop. The petitioners approached the tribunal by way of a fresh application which is pending, have approached the tribunal by way of a fresh application which is pending, full stop. Paragraph. In the meantime, on the basis of the assessment order dated March 25, 2025, notices of demand have been issued to the petitioner, full stop. It is submitted by the petitioner that the petitioner has made an application under section 220 within bracket 6 of the said Act of 1961 seeking stay of the demand, full stop. The petitioner seeks expeditious disposal, stay of the demand, full stop. Paragraph. It is submitted that the said application has not been disposed of and during pendency of the, and while keeping the said application, application pending, the respondent revenue authorities are proceeding to recover sums due in terms of the outstanding demand. Full stop. Paragraph. Mr. Dudhoria, learned advocate appearing for the respondent revenue authorities, submits that the application that has been shown to have been filed by the petitioners under section 220 within bracket 6 of the said Act of 1961 could not have been filed by the petitioners at all, inasmuch as upon the petitioner's bank account being attached. Where is that?
That is your lordship will finally see page number 306, 307, my lord. On they themselves said, my lord, that on their prayer, my lord, the attachment was lifted, and they themselves, my lord, they say that that they are ready to make the payments.
Attached.
Installment was on page number 307, lordship. Requested to unfreeze the account.
Where has it been?
My lord, lordship, 307, lordship.
307 is your order. That is not their letter.
My lord, installment was given, my lord, 550 lakhs on their, my lord. Bank account was defreezed, my lord, on their consent, my lord. This is the order, my
lord. The petitioners themselves approached the assessing officer.
Before the assessing officer, yes.
Approached the assessing officer and sought.
Their directors approached.
Sought to pay the demand in terms of by way of installments.
Yes.
Full stop. Attention of this court is drawn to a letter dated October 17, 2025, written on behalf of the petitioner within brackets at pages 308 and 309 of the writ petition, and the order dated November 25, 2025, wherein it has been recorded that the petitioner sought monthly payment option via email dated October 17, 2025, and undertook to make payment of the outstanding demand of rupees 8,73,40,410 within brackets including interest under section 220 within bracket 2 in installments starting 20th November 2025 of 50 lakh and remaining amount up to 30th April 2026 with a minimum payment of 75 lakh per month. Full stop. Paragraph. It is submitted that it was on such representation of the petitioner that the attachment of the petitioner's bank account was lifted. Full stop. It is further submitted that in such view of the matter, the petitioners are not entitled to any stay of the demand as requested by them by their letter dated, which is the letter?
This is the letter, my lord, the letter 17th of October 25, my lord. And my lord, they have failed to make the first installment, so that is also recorded, page number 310.
No. The letter of which they now seek consideration.
287, this is the date.
Application dated November 3. Application
November
filed,
3. November 3.
Application filed before the assessing officer. Letter by their application. by their application filed before the Deputy Commissioner Income Tax within bracket circle 1 within bracket 1
Yes.
within brackets page 287 to 295
Yes.
of the writ petition. Full stop. Paragraph. Third learned advocates appearing for the respective parties consider the material on record. Full stop. In view of the fact that the petitioner's appeal before the Income Tax Appellate Tribunal has not yet been restored, no mandatory order can be passed for stay of the demand as prayed for and in view of the fact that the petitioner has by its letter dated October 17, 2025 itself indicated to the assessing officer that the petitioner would be making payment of the outstanding demand by way of installments, no mandatory order of stay of the demand can be passed by this court. Full stop. However, since the petitioner has made an application for stay of notice under section 156 of the Income Tax Act, 1961, within brackets annexure P22 at pages 287 to 295 of the writ petition bracket closed, the respondent revenue authorities shall be free to take a decision on such application within a period of as expeditiously as possible, preferably within a period of 4 weeks from the date of communication of this order, strictly in accordance with law.
Only one that by submission, that is contention that I have admitted that denied. That is the
What is done on this?
It is recorded from the statement. From the statement.
Hard learned advocate said, ঠিক উপরে এটা লিখে দিন যে Mr. Banerjee, learned advocate appearing for the petitioner, submits that the petitioner has never undertaken to pay the outstanding demand.
Matter disposed of.
Yes. আর নিচে লিখে দিন, it is clarified that this court has that this order shall not be treated as a mandate to stay the demand, and the authority concerned shall be free to take appropriate decision independently in accordance with law. एक 5 मिनट बैठिए.
Wanted to see one of the schedule of admission program.
Yes.
Because I have been able to collect a copy.
My lord, I have taken instruction. I have come back with the instruction, my lord. Here, my lord. The only difficulty your lordship will see that all the students, all the guardians of the students who are make the application, my lord, all those schools are co-education schools. So it is not that they are studying in girls' schools. All those schools are co-education
No,
schools.
the question is of a better school, of a better school, better facility.
Lordship, that is the reason, your lordship. My lordship, kindly, my lord. Well, first we have to consider, your lordship, the school where all the students want to take admission. What is the existing student strength of the school? What is the existing teacher strength of the school? Because, my lord, teacher-pupil ratio is very important to maintain that facility or that whatever the students are asking for to maintain. That is very important. Is for students-teacher ratio. What is the school? So, my lord, if your lordship directs for extension, my lord, that's a separate part for admission for extension of the period of admission. My lord, kindly direct the DI to file a report on the next with your lordship regarding the total strength of the school and the teachers' strength of the school, and whether admission of excess students, I'm not telling excess at this moment of time because I don't know what is the strength. Whether admission of students, what is the existing and beyond that strength, whether the teacher pupil
Mr. Sanyal,
get diagnosed or not.
How many girl students are there in the school? They have girl students.
Now, no. You are asking for that. Not immediately I can answer.
But for that, well, there is only that that answer cannot be given by him because well, that is a policy of the education department. What will be the teacher-students ratio, teachers-people ratio? So, well, let the state file a report on the next date.
And kindly let me prima facie satisfy your loss. Now, suppose the petitioner's words are wanting admission to different classes, 5, 6, 7, all that. Now, let's take up example 5. Admission is going on, or just program has been given, the last date of admission not yet given. Now, suppose your loss is class 5 only one section, or class 5 has 3 sections. Each section must have 40. Now, this will be on the basis of merit. How could they exceed 40? I will be girl student, there will be boy student. On the basis of merit, 40 will be admitted. What the
No, well, that particular school have a primary section also. Yes. So, well, from that primary section, those students are they will get admitted in the promoted to the higher section, to primary section till class 4. The existing students of primary section of that particular school, which my learned friend 6 admission, there's a primary section. So those students will get promoted to class 5 in the higher section. And yes, but what are the rest? How many students can be admitted on merit as
Till such time that this petition is decided, I'll try to decide it. I don't know, but commencement of class, admission of session is on 2nd of January. Before that, how will I decide the petition? And what will happen?
I tell you
Because everything is in limbo.
That's why I'm right from the beginning chasing one after another. Before your lawsuits,
I have got only 1 month.
that's your lawsuit. That's not that, but I'm telling the facts. This was before the
Because it will become.
What I suggest your lordship, what I suggest your lordship, if your lordship, my lord, kindly extend the time. 2nd January is not the last date of admission. It is the last date of
2nd of January is the last date of admission.
No, I tell you, even the starting of class, it depends upon the school. That's the policy of the government.
That is why who is appearing for the school? I wanted to hear this. Yes.
This is Millard, kindly see. This is the Millard.
I'm not disposing it off today. Don't worry.
Mr. If your lordship would kind enough to
Yes, I've seen Mr. Bhattacharya. Can it not be extended for a week?
Lord, if your lordship directs me, Lord, it can be.
Because it is not a government notification.
I will not direct if your logistics don't permit, because I have to get your consensus also. You are the school. That will make things easier. If you can extend it, it will be easier for the court to come to a decision once for all. I'll decide this issue.
Yes.
Unnecessarily, I'll keep this pending, extending something, then coming to a decision. I'll decide whether these this 2004 notification, 2017 notification, where these are in accordance with law. If you can take instructions, come back, tell me now. I'll take it telephonically. I'll record that, extend it for a week. Within that week, Ms. Bhattacharya will also be ready with the opposition. If you want, I want to decide it. Shed it off.
State to
Rightly, wrongly, whatever.
Direction I'm wanting for, apart from extension, allow us to file our admission applications. Because I tell you, lawsuits, we are chasing for these schools. We will not apply to others.
No, I will shift the if the school permits this receiving of last date of admission form. If this is extended by a week, the entire thing will be extended by a week. Within that week, after the vacation, I'll decide the writ petition. I will decide whether you're entitled to that.
Gets it extended by a week from 2nd.
Yes.
To the 9th.
Yes.
So your lawsuits get it hard on 5th itself.
Yes, I'll hear it on 5th. I'll hear it on 5th. I'll hear it on 5th.
5th monthly list 6.
I don't have any monthly list. My list is the same every day. It is published same list is published every day.
Lordship.
My monthly is supplementary is monthly.
We have that mindset.
Mr. Bhattacharya, please come back. I am coming back in 5 minutes. Please come back and tell me, because I'll then level it. I will not keep it pending, keep it on my shoulders, shift it. I'll finish it.
Lordship.
Come back in 5 minutes. I'll record that only.
And well, one more thing, well, direction upon the DI to file a report regarding the student strength and the teacher people ratio.
Of all the schools are there.
No,
Why
particularly
is it
school.
required?
Why, my lord? Why I'm telling, my lord? Because this is a very good school as per the petitioners. All facilities. Now, my lord, if there is the students are taken, whatever permits the students teacher ratio and the infrastructure, and if the students become more than that, then all this good thing about the school will go. So, my lord, only a direction upon the state to file a report regarding the student strength and people teacher ratio of the particular school. My lord, that will be suffice. My lord, the lordship can decide.
Very well. File a report, we'll see.
Because if there's good school, it must be maintained. It should not be overburdened.
This writ petition has been filed Assignments are fast nowadays. It's all digital.
And I think nobody will take exceptions to that.
No. Let us have it on 5th. Let us see what happens on 5th. No, 32. Yes.
Your Lordship, I am for the state.
Yes, what has happened?
Order and higher authority order to remove some encroachment on the land of the one. But I am not on the those person whose against already been possibly initiated, requisition file and everything is started. I am the person I never been noticed, I never serve a notice. There is clear violation of section 8 of the West Bengal Violence.
Who is appearing for the Yes, madam.
Yes, Your Lordship.
Yes, madam. There is an allegation that the proceeding has been concluded in violation of principles of natural justice. You have not given him a hearing.
Your Lordship, the hearing was given in accordance to WPA number 11405 of 2022. Petitioner. That was heard by Honorable Justice Partha Sharati Chatterjee. Now, in that petition, the instant petitioner was not a party.
The
And now, Your Lordship,
you were there as a private respondent in that. And you are the person who is having the property there.
Several and order was passed and last occasion divisional commissioner passed. But the present petition is not a party of the respondent passed. But the order is passed there or then belong to the Jela. This petitioner made an application for paying for lease loans. Jela initiated process, but in the other notice, but
which notice page?
Page 38 last page, my lord.
Inspection, that is the inspection. The government wrote a letter to the block development officer to file a report to make an inquiry and inspection by the report. Due to land is jail officer. No? Petition is not more or less 50 members of the enclosure of the same matters. I am submit before the commissioner for the hearing and on just particularly more or less 50 numbers of the enclosure of the jail officer initiate against the 3 or 4 persons. It is a petitioner is not a party of this. Annex is document that if the annex says the document says
When did you come to know about this order? This order is passed in 2022.
But I just 3 days before filing this application, the person comes to the shop room and handed over this Xerox copy of it. He is not using the original form and indicating that your form is demo. But thereafter, petitioner asking for everything. I got it from online website of the court. I got thereafter I filed this petition with court. But is there any kind of encroachment, anything? Section 10 of the West Bengal Violence Act clearly indicates that I have to serve a notice. Section 10 was
land belonging to the
yes, but I can. Yes, but inhabitants land belongs to the Jila Police. The very vast page I mixed the plot.
So what is your authority to hold on to the land? How are you holding if it belongs to the Zilla Parishad?
But I made an application with Jila Parishad for lease of the property.
Whether lease has been granted? Then
taking now in consideration. When matter is pending, people fill up.
Where is your application for lease?
Madam, kindly take 36 point.
Yes, why have you not considered this application for lease?
Due to some matter is pending before this High Court and let's say 2 or 3 institutions pending now before the other matter is pending before the Judicial Commission, last Commission, Judicial Commission passed an order. But we kindly see the order of the Judicial Commission. The case is order, stated page 28, but main point of the order is 30, 29, one authority of the district as a authority. So all the structures fact that the land is given to the development party.
Where are you reading? Which page are you reading?
Page 29.
Yes. Where?
I have submitted before this Divisional Commission.
What are you placing at page 29?
This is the order of the Divisional Commission.
Yes.
This order is indicated that the all such order is the private responsible for not judicial.
Yes, so he should be given a notice.
Actually, I am not initiate any process for removal. Process is initiated by the state lordship. But the lordship, I would consider the representation for this in accordance with law. Give me some time, 1 or 2 months in accordance with law.
Where is the order of the subdivisional officer? This.
Not done. If the order is submitted, the same order is confirmed by the
Yes, who is appearing for the state? You don't execute this order as regards the petitioner till 5th or 6th. Let her come with a report. Because in the meantime, if the petitioner is evicted without hearing, that will not be good.
So I am not initiate process that process of the state laws.
You file a report. The writ petition alleges arbitrary action on the part of the respondent state authorities in evicting the writ petitioner in purported execution of an order dated November 10, 2025, passed by the Commissioner, Presidency Division. Full stop. It is apparent from the order dated November 10, 2025 that the same has been passed
Number 26.789.
upon hearing the following persons. It is apparent from the communication of the order, communication dated November 11, 2025. of the said order dated November 10, 2025, that the following persons have been heard. এইটা লিখে দিন 6, 7, 8 and 9 নামগুলো লিখে দেবেন। নির্মল চন্দ্র বাগ, বিমল চন্দ্র বাগ, বিদ্যুৎ রায় চৌধুরী, ভুবন। Full stop. The petitioner submits that the petitioner has been in occupation of the property in question and that the petitioner has also made an application before the respondent number respondent number 1A, respondent number 1A, i.e. South 24 Zilla Parishad, for grant of lease in respect of the property whereat the petitioner has his shop. You have a shop? Yes, sir. Full stop. Although the state respondents are represented, comma, it has not been demonstrated by the state respondents that any notice of hearing has been served upon the petitioner or that the petitioner has been heard prior to the passing of the order impugned. Full stop. The state respondents shall therefore file a report in the form of an affidavit disclosing as to how has the petitioner been served. Full stop. Petitioner been informed about the proceedings initiated under the West Bengal Highways Act, 1964. Full stop. Paragraph. The Zilla Parishad shall also file a report indicating the status of the petitioner's application as well as the status of the petitioner vis-a-vis the petitioner's occupation of the land of Zilla Parishad. You tell me what he is. If you also say that he is unauthorized, then this order will hold good for him. I'll send him back lock, stock, barrel. So, full stop. Paragraph. Since at present it is not clear. More or less 50 you come back by way of something which I can put on record. Oral submission, half I can make out, half I cannot make out. Since at present it is not clear as to whether the petitioner has been served with a notice or not, and as to whether the petitioner is in unauthorized occupation of the property in question or not, comma, the petitioner's occupation shall not be disturbed on the strength of the order impugned till
all our officer engaged, Lordship.
January.
It is not possible.
I will not grant time. I will call your officer then. Don't. He will have to file the report till January 12, 2026.
13.
January 12, January 13, January 13, 2026. The report shall be filed before this court on or before the returnable date. List this matter for further consideration on January 8, 2026. You will have to file or you face contempt. Before January 8, you bring the report. You are getting so much of time, you will not be able to file a report whether he is unauthorized occupation or not. No, sir, you file a report. Your interim order is only till 13. Madam, by 8th, you will also file a report showing how you have served.
Yes, your Lordship.
You will indicate the status that he is. It is clarified. It is clarified that this order shall not affect the eviction of the other persons whose names are appearing in the order, in the communication of the order, i.e. the letter dated November 11, 2025, they shall be bound by the order impugned. The protection is only for him because he has not been hurt.
I have submitted for them. I have mentioned that the 50 numbers of the enclosure of the six. All are.
I don't know. You tell me whether he is encroacher or not. Then we shall see. Bring it on record. 2022 will not give you status. If you are an encroacher, you will have to go.
All are persons are taken.
What is the urgency? If it has already been deducted, please wait. Next. Already been deducted, not today. There are other urgent matters where if it was attachment, it was a different thing. Yes.
This is with regard to decision of a recovery proceeding by the CGST authority. We have issued written is under section 79. Now, there is an interesting law point in this case. Whether I should be saddled with interest, I have to pay interest, admittedly, for delayed payment of tax. So whether that should be calculated from the last date of filing of the return till the date of payment of the tax or till the date of filing of the return. There are two judgments of two different high courts. One is Gujarat High Court division bench, another is my lord Madras High Court single bench. Both are in my favor. The issue is no longer restricting, my lord, in my humble submission. I've gone through.
Yes, Mr. Banerjee.
Well, over here, the department in this communication with regard to payment of interest has been going on since 6th April 2022. Now it
Mr. Siddiqui, some amount of interest is payable according to you also.
They have acknowledged it. Then passes interest, I have calculated it, I have paid it.
Well, it's page 147.
So balance sum, there is a threat of recovery.
Threat of the comes to page 147. That is annexure P30. But I just read down, my lord. Please refer to this office letter at the given number so and so and the reply dated so and so. You can see that with your header letter. In this regard, please refer to your reply dated so and so. There you have mentioned basically that with a notification number so and so dated so on proviso and with insert date under rule 88D1, which provides that provided that any amount has been created in the
Mr. Banerjee, till after the vacation, don't proceed with this. Because it is not that you have not been paid anything. Something has come. Yes, I have seen 56 lakh and odd has been paid. 60 and odd is remaining. Give me the judgment.
The contention which my learned friend are raising over here, well, it can be remanded back to this authority to take a decision in view of the settled position of law. That can expedite the whole issue.
That can be done. That can be done. Give me that.
I'll show the judgments.
In view of the judgments, Malad, let it be decided by that authority, Malad, it will resolve the whole issue. Yeah,
Likun. Mr. Siddiqui, paragraphs?
In the Gujarat High Court, the paragraphs are the date of payment of the tax, not from the date of filing of the return. The due date, when the buyer was supposed to pay the tax, from that date till the date of payment of tax, the interest is to be calculated. They are calculating that I pay the tax. After that, I file the return. So they are saying that it is to be calculated from the due date till the date of filing of the return. The Honorable Gujarat High Court Madras High Court also comes to paragraph 24. It is at page number 32 of the judgment. In view of the above analysis of the provision of the Act, the decided case laws of the reliance placed by the respondent so and so judgment, taking a contrary view, we are not in line of the provision of the Act under which made surrender, and therefore the same are not followed by judgment. Judgment in the case of Vishnu Aroma, the watching private limited is followed, and it is therefore held that the tax amount which has already been paid to the government by depositing an electronic cash credit ledger by the petitioner is required to be considered as a payment of tax, which gets adjusted at time of filing of the return by debiting the electronic cash ledger as per the scheme of the CGST Act, and therefore the question of payment of interest would not arise for the period from the date of deposit of the amount in the electronic cash ledger by the petitioner till the date of filing of the return. As per the provision of the Act, the amount deposited by the
No, Mr. Siddiqui, at page 147,
7.
yes, 147 of your writ petition.
The second paragraph.
Yes.
As per the above provision, interest on amount which is stated to the advantage before the due date of filing return did not be considered for calculation of interest.
That is what the Gujarat High Court is also saying. This is exactly that. But thereafter,
however,
as per the report submitted by the concerned range officer, it is seen that you had not credited the said amount into the electronic credit ledger before the date of filing of the returns.
I have credited that amount, right? That's
But that is the factual finding.
but you also can see the last paragraph.
Yes.
Their contention, accordingly, the contention made by you is not tenable, and the interest this they are saying, my lord, I just clarified. That language was not clear. I was showing the amount, that is why that language is shown. But if you also kindly comes to page 50. 50.
Mr. Siddiqui will hear it because it will take time.
On second.
On second, I'll hear it. I'm posting it because we are almost. I'll ask him to stay.
Because there are two judgments in that.
Since an arguable case has been made out, lordship for a limited.
This has to be.
We are not saying.
This
is purely on law points, madam.
This writ petition
I'm disturbing you.
What
I'm
happened?
renewing my prayer for partner. And let me look at the determinants. I heard it in the morning in respect of the other honorable judges. The I of 2024.
Well, instead of 6, can it be on 8?
8th, yes.
8.
8th. Third, Mr. Sanyal, it will be very difficult. Second, you make a prayer for a assignment, it will be assigned immediately.
It's not so easy, man.
It is easy, it is easy. Very easy. Third, yes, that is there, but there are difficulties. Third will be difficult, very difficult.
Again, in this way, earlier 3 represent coming first. I didn't get it.
You try it on second, it will be done. It will be done.
Then I have to pay for assignment.
Yes.
Then I have to get it listed before another honorable judge, get it released, then assigned. A very difficult task. Everybody we are not wanting that. One way or other, you will also.
Mr. Sanyal, I am hesitant. Third. You extend it for a few more days, and we'll get.
School authority will be difficulty.
So your difficulty is difficulty. My difficulty is no difficulty, na? You extend it for 3 days. I am pressing myself hard. Otherwise, hearing a matter on 5th is also not very easy. I am prepared for that. To extend it for 3 days, I'll do it on 6th. You get it assigned.
No, assignment I have to get it before the regular pay.
This mentioning that assigned for release will everybody will easily get it listed.
No problem, Mr. Borua may take exception again. He wants a delay. That's the problem.
Call. Mr. Raju, can it not wait till the vacation?
At the time of filing the petition, the notice was served as a statement by bank. But I was able to actually make the record.
Yes. But if other side is not there, please don't press. Come back on 2nd. The petitioner craves leave to file a supplementary.
Item 37.
Yes.
This matter, I need to take some instructions. Can I come back on Monday or on the 5th?
Who is appearing for the other side?
He is appearing.
Come back. It will be appearance 2nd.
On 5th.
Come back on 5th. Not a problem.
Only one request more. I'm sorry. But kindly record that it was substantially hard by you. Only this one. So that
Very
I can kindly record that.
I'll record. That will be clear from the first order also.
No. First order?
Yesterday's order.
Yesterday's order. But anyhow, you lost this.
Land matters are also there.
Last working day of the year.
C5.
We have been also given liberty, my lord. Based on issues there is an observation that it has to be completed by the 31st of December. We have been seeking for hearing, my lord. Or what is the hearing? I understand the state will also not stand in the way, my lord. Just a hearing, my lord. Let them hear us and thereafter, my lord, take whatever decision they intend to take, my lord.
My lord, the process is being continued by an order of the Honorable Division Bench, which my lord will find at page 153. I leave the rest on your lordships. My lord will kindly peruse the order once.
150?
153 of item number, my lord, 39, which is WPA 28614.
Yes.
My lord, this is the order. My lord, may I read therefrom, in view of the report filed by the state dated 10 September 2025, wherefrom it appears that water body had been filled up and construction had taken place in violation of section 23(1) of the West Bengal Panchayat Act, and also having regard to the fact that Karni Nirman Private Limited, who is the private respondent in this writ petition, had failed to turn up in spite of issuance of notice under section 4C5, have failed to turn up in spite of issuance of notice under 4C5 of the WBLR Act, we direct the authority concerned to take appropriate steps in accordance with law for restoration of water body. Thereafter, my lord, we do not find any reason to interfere with the steps already initiated by the authority. The proceeding already initiated under section 4C5 shall continue and should be concluded on or before 31st December 2025 in accordance with law. The persons aggrieved by the initiation of such proceedings may make appropriate representation before the authority is concerned. And then, my lord, thereafter, my lord, will also see Can 3 of 2025, paragraph 7. We do not find any merit in this application, as we are of the view that this application has been taken out to delay the restoration initiated under section 4C5 of the WBLR Act 1955. So, my lord, three things are clear. It was initiated way back, in fact, in 2021. Another thing is clear is that, my lord, the private respondent in this writ petition is the owner of the land which has been leased to the petitioners in this matter. The owners did never appeared. Very well, very well. I am in 13 and I am just, I raise no issue with regard to those facts. Those are admitted. So, my lord, the main person concerned, they do not appear. That has been recorded by the orders in the division bench. My lord, taking that in view, these orders were passed. Thereafter, my lord, probably they have challenged two notices, 25th of November 2025, which is again a notice by us to the owner, who is the private respondent, to comply with the High Court's direction, because we wanted them to take steps to restore. Thereafter, my lord, we make an interdepartmental communication saying that please let us know that these are the facts, let us know what to do next. I do not see how these have prejudiced the petitioners. Number one, they say that they want a hearing. It has been recorded by the division bench that nobody turned up in spite of, my lord, chances being given to them. Thereafter, we are supposed to proceed and conclude by 31st. And they have been making applications which have been dismissed on the finding that these applications are dilatory to prevent restoration. Now I leave the rest to your lordships. Lord, we do not, Lord, I today do not know what this Can 3 of 2025 was, because it has not been annexed. But again, this much is clear that there was a dilatory tactics made to defer the restoration. Of course, now beyond 31st
Without deferring the restoration, hearing is possible. Without deferring the
Can 1 and Can 2 be initially. Can 1 was with regard to maintainability, which was filed. Can 2?
Without extending the period from, I mean, beyond 31st, can hearing not be given?
I leave it on your lordships, Miller.
No, can hearing be given or not? That you cannot leave it on me. Hearing has to be given by you. So can you give it or not?
It is difficult, Miller, but maybe in a day or two.
They'll not be entitled to adjournments. You will fix a date on that day. If they appear, well and good. They don't appear, they don't appear. In terms of paragraph 4.
They will act in terms of this order only, No
Yes,
further.
in paragraph, no adjournment.
No
I
adjournment.
cannot extend. If division bench has fixed a time, I am powerless. The time fixed by them is.
If the date, my lord, here and now.
You give a date, I'll fix
My
it.
lord, I'll have to ask for the date from my office.
Ask it.
Yes. Now only if
Yes,
I may
yes.
do this.
Yes.
Let the court note it. বলো যে কোনো একদিন দিতে রিপোর্ট 31st ওই দিনে উইদাউট অ্যাডজার্নমেন্ট দশটা রেকর্ড করে দিই শুনবে ওরা জাস্ট শুনে নিতে হবে না ও ডিএলআর ভিডিও
26th is a Friday, they are open. 29th again is a Monday, 30th is Tuesday.
Whatever date they give, I'll fix it on that. I'm recording
Yes,
proceeding.
my lord, that will be clear.
I'll keep the date open. This writ petition,
Yes.
So, what is your instruction? When will the same person will hear?
Same, one by the lessor, one by the lessee.
Yes. One by the owner, one by the lessee. Riot, recorded riot. 40 is by the recorded riot, 39 is by the lessee.
Proceed. So the letter was the letter which you showed was not
Lord,
addressed to the petitioner there, to the lesser of the petitioner, no?
Yes, madam.
Who is the lesser? Karni Nirma.
Karni.
ওখানে যেখানে letter
Karni is the
লিখেছেন,
riot. Who is the also the lesser?
page 39 এ একটা আপনি লিখে Thank you.
Chalo.
WPA disposed of দুটোই।
The next matter. Already 115.
All land has provided to drawn law by the Kolkata Municipal Development Corporation under the East Kolkata Development Project Phase 1 in the year 1997. He constructed a small house after making care of. But he has a business of selling shadi, and in Calcutta, he has a shop manager because the guy that to page 24.
24.
But the license, his house in manner caused by area, got a shop running his shadi business from that part of that room next to it. So now what happened during COVID, being a handicapped person, he could not go to his shop, and some sarees has been taken in. After normal situation, he again started his business from the shop room, not from the house. In the meantime, a show cause notice suddenly has been issued, so to kindly turn to the show cause notice at page 46. And I'm not attracted with was first one, but I'm attracted with 2.9 of the agreement I shall show to you. There is no such permission to make any direction to make payment of penalty. Can you read my page 46? Or use other partner. That's the only charge. I submitted it in fact saying all these things that during COVID period only I have done so. I have sold some sarees during COVID period from that. Then the final order has been passed by page 47. Demand of 40 lakhs. Now, can you see my lord, nothing has been disclosed under which provision of law they are entitled to make such demand. If I raise some otherwise construction contrary to the law, then they can. That is clause 2. Roman.
They say change of purpose, residential to commercial.
That does not be before filing after the agreement is was 2 Roman 9 from bottom of third paragraph. Not to use or allowed to be used the device that and the structure thereof or any part thereof for any purpose other than the
Page
residential
32, 9.
Yes, 32.
2.9.
2.9.
Yes.
There is no such permission to impose any penalty, which permits by the Roman 5. Can you see by the Roman 5? I am not attracted with Roman 5. If I raise any construction contrary to the sanction plan, in that case, my lord, for demolition of that portion, this money can be demanded. And can you see the order is due, my lord? No reason, nothing. Nothing. No opportunity of hearing. The huge demand of rupees 40 lakhs.
And is it admitted that it has been changed from residential to commercial?
This is there. Residential, I get some shun during COVID. I have a shop in other place in Calcutta.
So there is no change of user.
No, that is not the case also. Kindly come to my order include page 47. Kindly read my second paragraph. The same. First paragraph. The understanding directed to request you to deposit the amount of rupees so.
Yes, yes, there is nothing mentioned.
Yes, towards service charge for change of purpose. That is not case made out that I have constructed something else.
Yes.
My lord, here.
Well, just one line. But I have not been provided any opportunity of it. Your Lordship, dispose of the matter directing them that I shall make a detailed representation. They will consider the same after providing me opportunity of hearing so that I can produce all the documents. This order has been passed without providing me opportunity of hearing. Despite submission.
What is your instruction on this?
My lord, here this allotment was made for.
Very well. I'm keeping it after vacation immediately.
Yeah.
You.
There is no immediate threat. If you
I will. What?
Demand, but
suppose if you don't pay, what will happen? Nothing will happen.
No. That is not. Kindly have a look. Page 47. Nothing.
I will record that. I will record that there is nothing that is cancelling. So
there is no immediate threat.
That there is no immediate threat. That is a submission.
Yeah. That appears from the document itself.
This writ petition lays challenge to a notice the end of February 2026. Full stop. List this matter for hearing in the list this matter very well, very well. List this matter as directed in the order dated December 22, 2020. ঠিক আছে?
Item number 2.
Same order. Extension. Give your name. Same order, same order.
Item number 3.
Same order.
Item number 4.
Same order.
Under Article 5. I have got care of it. Last question, your lordship directed them to come up with instruction. Not me, I am requesting the Union of India answering this comment. One lady was appearing. Very well, we will come after that. Grateful to you. Item number 6. Can you have it after it? Item number 7. Item number 8. It also will ask. Other side is not. No, the other side is not here. So the other my junior is not here. So I can't go to that. Item number 9.
Item number 9. It's otherwise covered, your ownership, by a decision of the coordinate bench of this honorable High Court. Mr. Dudoria, but any day after vacation, why may we please to fix it? The date may be fixed if I may keep it. I'm grateful. I'm grateful.
Item number 10. 11. Kindly keep it after 50. I'm led by Mr. Kar. I'm led. Item number 30. 14. 15.
My lords, I'm appearing online. Kindly permit me to appear online for this matter, my lords. In this case, 148 has been issued, my lords. My lords, I'm not able to hear you. With your voice is too little faint.
There is nobody for the respondents. Actually,
Okay.
it's the last day before the
Yes,
closing.
yes, my lords. But my lords, my only request is that
It will retain its position in the list. Again, it will be called on 2nd.
I would like to come physically. If my lords can give me a particular date and I can come back.
The fixing of date will not be possible. It will be there in the list. It will appear as it is on 2nd of January when the court reopens.
Can I request, my lord, because this is a complete breach of legal provisions, because I had filed my return. Now my return, and I have explained everything. Now can an interim stay be given, because I have to otherwise I have to comply with the 148 proceedings. I'm a employee of Reckitt Benetton, and I've filed a return of 3.73 crores, and I've explained everything to the officer. He's only saying that because in Punjab and High Court.
Very well, the proceedings will not be concluded immediately on 2nd or before that. Let us come back on 2nd. We'll hear it. Let it be heard in the presence of the other side.
Grateful, my lords. Grateful, my lords.
It's just a reopening notice now. Yes.
by the baseless matter. That officer had
Who is appearing for the, Mr. Sharma, you are appearing?
70.
You are there.
I'm for the respondent, Your Lordship. I'm led by Mr. Arjo Dutt, Your Lordship. He's not coming today, so Your Lordship may kindly grant today, not today.
Making it not today, again it will appear on 2nd. In the prayer. Very well, I'll grant you leave to correct it. You want to leave now? It is submitted by the learned advocate appearing this writ petition has been filed
My lord, I am appearing for item number 18, 19, 20.
Your Lordship, I'm for the respondent, Your Lordship. I'm led by Mr. Shivshankar Banerjee, and we are yet to receive the instructions, Your Lordship.
Lordship is not audible. My lord, lordship is not audible.
Petitioner is not there.
Fine, lordship. Lordship, I was also there in item number 18 and 19, if your lordship kindly.
Yes, yes. Your learned friend is here.
Yes, yes, lordship. I'm deeply obliged, my lord.
On the last day, we don't take note of online appearances. Your appearance will not be marked.
I convey my New Year greetings and Christmas greetings to my lord.
No, no, you are offline. If you come offline, only then. No online on last day.
Lord.
Yes. Not today. Not today. Not today. Not today.
Only for the respondent.
26, 27, 26, 27, 28 are all identical, more or less similar matters. Your
After 5th, Mr. Junjanwala.
if it may be fixed on 6th, Your Lordship.
We can have it on 6th. As requested by learned advocate, by Mr. Sharma, learned advocate.
number 30. One of the points here is good. Other matters are not.
Oh, that direct notice.
Yes, one of the points here. That is that matter.
Where that matter is fixed on which date? This can appear on 5th. দুটো সময় করা হয়েছে না ওটা নাকি একটা as a continuing matter. So let this matter appear along with that. Because if the point is the same,
Point is the same. Here, of course, the Bible's question is not there.
but that point is there.
That file an objection, citing GK right now, they have not
Considered it. So this point will be resolved in both then. ওই ওর নাম্বারটা আছে লিখে দিন Mr. Khetan, learned senior advocate appearing for the petitioner, submits that the issue involved in this writ petition is similar to the one involved in not today. As prayed for by learned advocate appearing for বসে লিখুন adjournment appearing for the petition. কল করে যান না থাকলে আর
Item number 33 and 34, my lord, I am appearing virtually, my lord. I am praying adjournment, my lord. May it be fixed after vacation.
not today.
Yes, not today. I am grateful, my lord.
Item number 37, 38, for order, item number 39, item motion, item number 40.
Your Lordship, I am appearing for item number 40 to 44 virtually, Your Lordship. I'm praying for a not today, Your Lordship.
Not today.
42.
Your Lordship, I'm appearing in item number 38 virtually.
Madam, 38 has been already made not today. Nobody responded.
Noted, Your Lordship.
Yes. 44.
45, 46, 47, 48, 49, 50, 51, 52, 53, for hearing unapproved documents, 54, for hearing group 2, item number 55.
Not today, not today. Not today. Not required. It will go out of my list after the not today only. Chalo, next.
Much obliged.
For hearing 4, item number 56, 7, 8, 9, 60, 51, 53, 4, 5, 6, 7, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96,
covered my lots also. Well, this final application was expiring on 31st March and partly assessment. Protection is being granted to me, and the affidavits are also mentioned.
Who is the person appearing for? Talk with them. We'll upgrade it. If it is a covered issue, we'll take it.
I'm grateful. But I have informed Mr. Bhumik is coming. I'm grateful.
Special matters, item number 97, 98.
98 minute, I'm appearing on behalf of High Court administration. Minute, we can come back after vacation.
Come back, my lord, since it's a SI pattern of the it's a day for
Especially assigned matters will be taken up on Fridays. I'll indicate that in the list.
Great. Grateful. Great.
Thank you, Mr. Ben. Yes. ওই
Yes.
ম্যাটারটা ওই আইটেম 28 ছিল বলে না কত ছিল সরি 31 আইটেম 31 30 and 31 দিদি 30 and 31 এ ওই যে অর্ডারটা রেকর্ড হয়েছে হ্যাঁ হ্যাঁ কি অর্ডার রেকর্ড হলো স্টার্ট লিখে দিন কেটে দিন এখন যেটা বলছি সেটা লিখে দিন heard Mr. Khetan, learned senior
New Year, my lord. Happy New Year, my lord. New Year.